Good morning, everyone. My name is Tara Moffat. I'm an attorney with Gervin and Ferlazzo. We're a school district law firm. I represent about 70 different school districts, including several BOCES, where we work together to try to make sure districts are complying with the law. And in doing so, it helps me keep up to date and up to speed on all things special education, which is why I love being part of Special Education Task Force, because it gives me the opportunity to share that information and knowledge with others in the hope that we can all recognize that special education law is what we are all required to follow and adhere to, and also make sure that we're meeting the needs of students with disabilities. I believe that the right to an education is one of the greatest rights that we give to all of our students, and the message that students with disabilities have those same rights is a critical message, and one that is shared vision for all of us on the task force. And so we thank you for being here and hope that you find this information informative. So I'm going to dive right into the presentation and cover a number of new guidance and key topics in special education. Knowing that, we have an audience that includes a variety of different professionals, as well as teachers, administrators, directors of special education, parents, advocates, representatives from the state education department. I'm going to be speaking in terms of information that is available. I will highlight the source of this info, and I will tell you that in the PowerPoint, the orange links are all hyperlinks, so you can get right to the document so that you don't need to hunt them down after. Hopefully this will all work and you'll be able to get to it. If not, if you need to find those documents, you could just go based on the title and you should be able to find it if you plug it in. So one of the biggest issues all districts have faced this year is statistics on staffing shortages. I imagine that no one is surprised to hear, we hear it on the news every day, about the challenges with ensuring that we have adequate staff, adequate, transportation and special education have been two primary areas. There was a new guidance, a new poll that was issued just at the end of September. 53% of public schools felt they were understaffed going into the start of the school year. I can vouch that that continues to be, a painful reality. We're working hard to make sure that districts get the staff that they need, and there are some creative, supports that are being offered through the state to assist us with fulfilling those obligations. And we're also looking creatively at how we can, help staff perhaps explore other training options. But at the end of the day, the most understaffed positions are special education teachers, 65% of the areas that are understaffed, and transportation staff. Transportation has been probably one of the biggest challenges this year, because we have, students who need to go to programs that are not in their immediate area. However, when you have a shortage of bus drivers, that automatically relates to longer rides, which can potentially lead to behaviors and other challenges that we might not experience had we have more transportation. Most folks are working very hard on recruitment, have revisited their compensation packages, but it continues to be a struggle. So if you know anyone who wants to be a bus driver, please encourage them to consider applying and working with their local school district. Okay, so one of the important things to note, though, is regardless of the challenges with staffing, the Office of Special Education Program, that's OSEP, it's the Office of Special Education Program for the Department of Education. The Federal Education Department issued guidance just on October 4th, reminding staff that there is no flexibility on waiving requirements for highly qualified staff to provide special ed instruction or related services, that you cannot waive it on a provisional, emergency, or other basis. So while there are certain flexibilities that the state can afford to us, that is one that is not permitted. And so all staff still have to meet the criteria and qualification to be able to provide that support and service. Now, this does not mean that there cannot be a short-term substitute, or there may not be, times when you have someone else filling in, but at the end of the day, we need to make sure that we have qualified staff that are providing that instruction in order to support the needs of our students. Just in terms of what are IDEA staff qualifications, special education teachers have to have the appropriate state certification to be able to provide special education, including passing licensing exams or other similar measures to meet those qualifications. And related service providers in New York, again, where we reside, they need to have the appropriate certification and licensing, and then there are registrations and ongoing training requirements that they must maintain. And so that pretty much comes back to, our obligations to provide instruction to students with disabilities is the same, notwithstanding the numerous challenges that we face, both, from a parent perspective in terms of, challenges with how long our kids may be on the bus, and with, districts in terms of making sure we have the necessary people and staff to implement IEPs and support students in the classroom. I would say one of the biggest developments of new guidance this year relates to student discipline. And this is one that the Federal Education Department and New York State Education Departments are looking at very intensely based on some of the civil rights data. So we're going to talk a little bit about new guidance on IDEA and Section 504 discipline, as well as concepts of restraint and seclusion, and where the state is at on this particular issue in light of some new legislation. So in October, the Department of Education booted out a ton of new guidance. First off, they issued guidance on discipline for both IDEA and Section 504 at the same time on the same day. They issued about 7 different documents, which is, it's an indication as to how significant they feel that this issue is, to make sure that, we are improving our implementation of follow through on Section 504 and IDEA obligations, but also looking at making sure we are addressing the rights of students with disabilities when it comes to discipline. And issues such as removals or exclusionary practices have placed a large number of students with disabilities at risk of not, completing education, of, failing to meet their expectations. So it's very important that we look at the equity and the assignment of exclusion to make sure that there is not a disproportionate impact of the use of discipline on students with disabilities. It is not to say that students with disabilities are not subject to, the codes of conduct or discipline, but there are additional rights and protections that apply to students with disabilities, which we're going to go through in the context of these documents and the guidance. So just to kind of give you an understanding about why this is such a significant issue for, students with disabilities, that preschool students who have IEPs account for 22.7% of enrollment, but 56.9% of students who are expelled. Now, in New York, we don't really have expulsion, but, some of the private programs will refuse to continue to work with students, and we, struggle with those issues. But you can see that that's a disproportionate. Now, these are nationwide, not exclusive to New York data, but it's a pretty scary statistic. And then when you look at students who are classified under IDEA, we're 13% of the enrollment, but they've already received 20.5% of suspensions, and more out of school suspensions, 24.5%. When your numbers are bigger than your actual population, it goes to show that these are potentially kids who are being suspended on multiple occasions, which really goes to show the question of, is that, exclusionary practice really working to resolve those issues or not? And, the other issue that we'll be talking about is restraint and seclusion, and that we have a large number of students with disabilities who are being either subject to physical restraint or seclusion, even though they're only 13.2% of students in public schools. Almost 90% of students in public schools are, almost 90% of our students with disabilities are actually served in a public program, whether it's a BOCES or a public school. So we really don't have comparatively a large number of students that are going out. So when you look at that number, and you see the elevated levels of restraints and seclusions, it's a concern that we have a lot of movement and a lot of practices to go. And it really comes down to information, understanding, and recognition that there are other options available. So first off, I'm going to talk about the guidance document related to Section 504 and students with discipline. So for those who are not familiar, Section 504 is a civil rights law. It actually applies first to grave, which just means that if you're an individual with a disability that causes a substantial limitation on a major life activity, you're A, protected from discrimination, and B, entitled to reasonable supports, aids, or accommodations. We see Section 504 at work in the employment context, but in schools, we are usually looking at access and comparable access for students with disabilities in order to participate in the federally funded public education programs or services. When you have students with disabilities, there are also additional rights that attach when it comes to students who may be subject to a change of placement. And the change of placement is basically when the student will be removed from their regular education program due to disciplinary actions or a pattern of removals that potentially could deprive them of access to FAPE unless certain measures are taken. And FAPE, if you're not familiar, free appropriate public education. Special ed is all about acronyms, so I'll do my best to break them down, but that's really, one of our concerns. So basically, our goal when we talk about application of discipline is to ensure that we're not disciplining students for conduct that is, directly or substantially related to their disability or results as a consequence of the failure to implement the IEP as written to provide the services or the 504 plan that we determined the student needed in order to have comparable access. So this guidance document that was issued really kind of covers all of the obligations. One is that under 504, you also have obligations to evaluate and identify behavioral needs and to ensure that those needs are being appropriately met. I give reference to the different pages where these questions are addressed or the concepts are addressed within the document in case you're looking for the easy highlights to get to some of these key points. There is a unique component under Section 504 where someone who's engaged in active current illegal drug or alcohol use are not going to have some of the same protections, but if they're in recovery or treatment, then those disability rights still apply and they would be additionally protected. At the end of the day, a student with a 504 plan who's facing a change of circumstance, a change of placement, is entitled to a manifestation determination. We typically borrow from the IDEA what we believe is, the manifestation determination process, which we will look at the information and evaluations and reports of the student in the file, input and observations from the teachers and providers, and input and concerns of the parent and student to review two key questions. One is, was the conduct directly and substantially related to the underlying disability? Or two, did the failure to implement, in this case, the 504 plan, cause the conduct in question? And there's, when it's 504, it really does depend because 504 is a very broad law. And we usually will have students with 504 plans, typically when they don't require ongoing or regular specialized instruction or related services. More often than not, kids with a 504 plan will have accommodations or aids or services, accommodations in terms of time or testing or program adaptations or physical adaptations to their environment or presentation adaptations. So often it may not be a significant amount of students with 504 where it will be a manifestation, but nonetheless, the rights and entitlements are still there. And we need to go through that process to make sure that we are addressing the needs of the students appropriately through the 504 plan once they're deemed eligible, and that if they are then subject to discipline or removal, we go back and do that manifestation before any change of placement. And a change of placement is basically that magic line you cross between day 10 of removal and day 11, where that's when all of the additional procedural rights come into play. So at the same time in July, they issued a number of additional guidance documents, which all happened to fall at the same time. The Dear Colleague letter, which is basically Office of Special Education Programs saying, hey, world, this is a really important issue and we want to make sure that you're aware of our concerns and our expectations. The Dear Colleague letter is kind of the precursor to say this is why we think that this is an important issue. And then they included both a questions and answers specifically for addressing the needs of children with disabilities who have IEPs or who are potentially eligible for IEPs, and I'm going to talk about that magical presumed student status, as well as a guidance document that provides some information about other positive proactive responses, because again, discipline as a whole is designed to try to provide a consequence to student misconduct or behavior with the hope that it will prevent that student from engaging in that same behavior in the future. Discipline which does not address that need and is not resolving that may not be effective, which is why we also look at other matters. And the reality is the more students are suspended or removed from school, the harder it is for them to A, keep up with those expectations, and B, to meet the benchmarks or obligations. And it also has other effects such as loss of socialization and interaction, and it can also create negative experiences, which we really want to be mindful of. So when we talk about the IDEA and student discipline, the first is they issued a 57-page document. So I give you that just to help you understand how significant they feel this guidance is that they kicked out 57 pages. But I did find that it was, and yes, I read all the pages of every document that I'm referencing. It's a huge stack of paper. But going back to it, it really goes to cover basically from soup to nuts what it is to know that we need to do under the IDEA to address students with disabilities, including the obligation to provide and support behavioral needs of students with disabilities. And that can be through your building level support, such as RTI or response to intervention or multi-tier support systems, your MTSS. It can also be through PBIS, again, more acronyms, the Positive Behavioral Intervention System, as well as other supports that we may provide, such as building-based counseling, other social skills and development, as well as specialized instruction under IDEA. But the point is that we need to look at the students' needs as they present and address issues which may interfere with the student's ability to access programs and services. When it comes to discipline, we have to also recognize that there are certain discipline that does not constitute a change of placement. So basically, for the first 10 days of discipline or removal of a student within a calendar school year, we will treat a non-disabled student the same as, we will treat a student with a disability the same as we would treat a non-disabled student, which means that they're subject to the possibility of suspension or removal or detentions or referrals, just like anyone else. But when those removals, which can be a partial day, it can be a half day, it can be a full day, it can be in or out of school suspension, that continuously is monitored. And if you get to the point where you're about to cross a 10th day, there's a mandate that the district has to have a manifestation determination review. And that really is a review to determine whether the conduct was directly and substantially related to the student's underlying disability, as opposed to choice, because the reality is kids with disabilities are kids first. So not every kid is going to make the best decision. Sometimes the decisions may trigger or result directly from their disability, and other times it's just children make not the best decisions at times. And this is really to make sure that we're reviewing carefully to ensure that we're not disciplining students for conduct that is directly and substantially related to their disability. But we do recognize that students with disabilities are potentially subject to disciplinary removal, including some special considerations where the conduct of the student, even if it were a manifestation, is deemed so problematic and unsafe that there are additional measures that districts can take, and that allows a removal for up to 45 school days for certain exceptions. And that's basically serious bodily injury, possession of drugs or weapons on school grounds. And those are really kind of the limited exceptions. So kind of going back to it, there are specific requirements that we develop a manifestation determination review, and that if you are determining that the student may be still subject to additional discipline, either because it's one of those 45-day exceptions, or because the student is not a manifestation, then the CSE has to make a determination and a recommendation of an IAES, which is an interim alternative education setting. And the IAES is basically what the student will receive, even though it may be in a different setting, to ensure that they can continue to make progress towards their goals and to access their programs and services. So going back to the basic core concept, students with disabilities have rights. As for the first 10 days, they have the same rights that are afforded to all students under Education Law Section 3214, which is basically the law that provides the step-by-step process through which students have certain rights to notice, the rights to access evidence or to cross-examine complaining witnesses, the right to a hearing, the right to decisions and outcomes and appeal rights for discipline of any student who violates the code of conduct. For students with disabilities, we have to be mindful that we look at their IEP in particular and make sure that we have appropriately addressed the student's needs through programs and services. IDEA does not define discipline. And to be clear, there is no specific limitation, with the exception of 45-day exceptions, that you cannot suspend or remove a student with a disability for more than X period of time. However, it should be no different than the disposition that you would appoint to a non-disabled student for similar conduct with a similar record. And so, it's not that we should be looking at discipline, and willfully throwing students out to the, out on a long-term removal, but really making sure that, we have addressed appropriately student needs through the IEP programs and services, and then B, if they are subject to discipline when we're getting to that point where they're going to cross that 10th day, making sure we do a manifestation determination review. And then if the student will potentially be subject to more discipline. And remember, the CSE doesn't impose discipline. The CSE's role is to provide support and access to special education and services for a student with a disability. The decision regarding discipline is an administrative decision that is handled through the building level principal, or the suspension through a superintendent's hearing, or through a hearing officer that's then reviewed by the superintendent's hearing. Sometimes we've had folks who've come forward and say, well, I need to convince the CSE that discipline shouldn't be imposed. Discipline, and an imposition of discipline, does not get decided by the CSE. What the CSE looks at is whether or not the conduct is a manifestation of the student's disability or not, and then they recommend appropriate supports and services. And then we sort of touched upon those 45-day exceptions: drugs, weapons, and serious bodily injury. All of the IDEA rights are also delineated in New York State's Part 201 regulations of the commissioner, and they break them down section by section. So each of these areas, manifestation, determination, IAEF, is spelled out within those regulations. So change of placement, there's a very specific question that addresses it. And again, just to help everyone understand and have the same concept, that a change of placement is whenever a student is subject to removal for more than 10 either consecutive days or a pattern of removals that constitute up to 10 days in a calendar school year. It's important to note in a calendar school year, because the first 10 days, they're treated like a non-disabled, they're treated just the same as a non-disabled student. After 10 days, for any disciplinary removal thereafter, that student is entitled to a manifestation determination. There is no restarting of the clock. It doesn't go back to zero. You don't get an additional 10 days. Once you have made that determination, and once that student has crossed that barrier, they're entitled to those additional procedural rights each and every time thereafter. And the reason being is because we recognize the importance of, students being in school, and that we want to ensure that we are not, disproportionately impacting students with disabilities by removal. We look at also some factors such as, the similarity of behavior and whether or not the students have been removed proximity from one another of different disciplinary consequences. The decision on change of placement is ultimately determined by a district, but I would typically say to my districts, if you're at the 10th day, yes, you have the ability to say, do they have any similarity? Are they not a pattern? But I would say the default is usually going to be, presume you have an obligation to do that manifestation determination and hold that meeting and do it according to the process. And also not just hold the meeting, but then issue prior written notice, which is PWN, following the meeting, to advise of the outcome of that manifestation determination process, and to remind and advise parents of their rights if they disagree with that determination, that they can challenge that decision, or that they can appeal a recommendation of an IAEF, which is that alternative program or service that the student will receive. So another question that comes up often is in-school suspensions. Can they count towards that change of placement? And the answer is yes, unless the student is basically getting the same opportunities to participate in the general education curriculum and having the same access to their peers or related services that they would if they were in their program. So for example, if you had a student who was removed from classroom A and was placed in another location where they were still accessing, participating virtually through the same program, that might not be deemed a change of placement, because they're still accessing all of their programs and services, and they still have the ability to engage with their peers. But if they're in a alternative setting where they don't have the continued instruction being provided, or the students are working on packets instead of actually receiving instruction, or they're not receiving their related services, then yes, those will count towards those 10-day change of placement numbers. So a manifestation determination review is conducted by relevant members of the IEP team or the CSE, okay? And so that's determined by the parent and district. Typically, when you're talking about students who have had discipline or are being, faced with the possibility of discipline, your CSE manifestation determination team will definitely be, at a minimum, your chairperson and a psychologist or a behavioral specialist, as well as the parent and potentially the student. And then the other individuals who may have knowledge or information that is relevant to that decision. So that could be the special education teacher or the gen ed teacher or both, depending upon if the student is in those environments. And then it can also be other additional people who either the parent or the district feel have relevant information. Sometimes the building administrator, sometimes it'll be an outside provider, but that membership of that manifestation determination team is not set in stone, unlike the Knights of the Round Table for CSE, where we know exactly who has to be there, and then you can always add. They basically are going to look at the information in the student's file, and they have two questions: whether or not the conduct was caused by or had a direct and substantial relationship to the disability, or if the behavior was the result of the failure to implement the IEP. So for example, caused by or direct and substantial relationship to the disability. We have students who may bring a weapon to school, and unless they, their disability is their Magneto from the X-Men, and so magically anything metal sticks to them, I don't think that possession of a weapon is likely to be an automatic manifestation, and that's also one of those 45-day exceptions. But on the other hand, if a student were, accidentally, striking another student is a violation. However, if that student accidentally ends up injuring another student in the course of having a seizure, and they, their limbs were flailing and they accidentally, broke another student's nose, we're not going to discipline them. Obviously we recognize that that other student was on the receiving end, and that is certainly not something that we minimize, but at the same point in time, that is clearly directly and substantially related to the student's disability. Usually the determinations are much easier for the far ends of the spectrum, kids who are very cognitively low or kids who have very extreme mental health issues. It's the in-between, where it may not be as self-evident, and that's really where the discussion of the manifestation determination review team is important. And it's based on what's in the IEP, what's in the file, and observations and input from the committee members. Failure to implement the IEP, examples may be if you had a counseling support that was supposed to be there, but the counselor is out on maternity and the district didn't have a replacement staff member providing that service. If that potentially led to the student's reaction or behavior because they were not getting those tools and reinforcement that they needed, then that might be deemed a manifestation due to the failure to implement the IEP. And again, these are targeted because it's related to the disability. It has to be about the student's disability, not, individually, kids with ADHD may make poor decisions. Well, that may be true, but that may not be applicable in this particular case. And we really need to look at the facts and circumstance when making that determination as applied to this student and their needs and IEP, and not think of disability or categorical disabilities as a whole, because it's about this student. This is the I in the IEP, and we always go back to that. You must do that whenever there's a proposed change of placement. That's that magical 10th day. Everyone asks, what happens if we don't come to consensus at the meeting? Say we have, a split where some feel it's a manifestation, some feel it's not. At the end of the day, the decision has to be made at that meeting. So often that will come down to the chairperson will make the final determination. And following that, they need to make sure that they provide notice of the determination. That also includes notice of the rights and the procedural safeguards. If it's the first suspension, removal, manifestation within a calendar school year, you must provide a copy of the notice of procedural safeguards. But it's also an important practice that I always say, make sure that you're providing notice of rights at all times. Every meeting, I always encourage people to offer a copy of the Notice of Procedural Safeguards, because it also reminds people about the rights and entitlements for both students with disabilities, as well as the potential obligations for districts as to what they need to be doing in order to comply with the law. And then after that, if there is a subsequent discipline following that first change of placement, each and every time you're going to have to do another manifestation determination review. And that's an important part to make sure is communicated to your general education staff and administration, because there are rights and triggers that may prevent an immediate removal, because we have to follow Education Law 3214, which requires notice prior to removal of a student, except for a very limited number of cases where they believe that maintaining the student is dangerous. And there's a pretty high standard for that. So the goal is, in most cases, we are not looking for that immediate removal, but notice and the opportunity, to address that. And the whole point of the notice is to give parents and the student the opportunity to share their version of events and to determine whether or not that might impact the disciplining party's decision on whether or not to impose discipline and to what extent discipline would be imposed. If the conduct is determined to be a manifestation, then one, discipline typically ends, with the exception of a 45-day, and I'll keep referencing that, but typically the discipline ends, the student returns to their program unless the parties agree to something else, and you either conduct a FBA, which is a functional behavioral assessment. That's basically trying to understand what is the function, or what is it that the student is getting out of the behavior, or what is the reinforcing consequence of the behavior that may be leading them to engage in that behavior. What are the triggering events or antecedents? What is potentially making them continue to follow this pattern, or what skills do they lack that might be necessary to teach in order to divert that pattern of behavior? That's what the functional behavioral assessment does, and it provides us kind of the understanding as to what triggers, why is the student doing what they're doing, what's reinforcing that, and in consequences, what is reinforcing the outcome, not what's the penalty. The consequences, why is the student continuing to do that? For example, we had a principal, a wonderful, lovely, kind principal, who had a popcorn machine in their office. And so we had a couple of kids with disabilities who are very clever, who realized that each time they got sent to the principal's office, they got popcorn. So we had a negative reinforcing consequence because there was a reward at the end of the disciplinary tunnel. And we did have to address that and, make sure that we weren't, inadvertently reinforcing that negative behavior. So the popcorn machine went away. I know I'm the worst person ever, but nonetheless, we also recognize that you've got to look at what may be reinforcing that behavior, and then make a plan, a behavior intervention plan, to specifically target those behaviors and control what you can control. And that is typically the environment, the timing, the level of demand being placed on the student, the wording you may use, the communication, verbal or nonverbal, the amount of wait time you give. These are things, or the proximity of the student to others or certain events. These are things that you can control to try to prevent the antecedent behavior. You also have to teach replacement behaviors. And candidly, trying to teach a replacement behavior in the heat of a crisis is not going to work. So we have to do that instruction and reinforce the proper outcome or alternative behavior that we would rather the student do in times when they're calm and in a good place, and we can have that discussion with the goal of building their capacity to present their frustration in another manner. Let them use their words, let them indicate I need a break, provide them some other strategy where they can still have their needs met, but that does not result in behavior that may be subject to discipline or removal. And so those are what behavior intervention plans address. And the most important thing about a behavior intervention plan is not just to draft it, but then to use it, implement it, and monitor it. And that's really where data and documentation of whether or not these strategies are effective is an incredibly important part. Because if it's not working, then we need to change. But the only way you can do that is if you have data collected over time to review, are we seeing a reduction in these problematic behaviors? Are we seeing a decline in the frequency or the intensity or the duration of these behaviors, or are they less frequent? If you're seeing that, then we may continue with those interventions. If we're not, over a period of time, then we may need to re-strategize The reality is when you're working with kids with disabilities and discipline, it's kind of like whack-a-mole. You will extinguish one behavior and another one pops up, which is, part and parcel of understanding the challenges with working with students with disabilities. But that is why, we may have many reviews and updates to behavior intervention plans or, targeted issues, because kids change over time. So if we determine that the student's conduct is a manifestation, you either conduct and review an FBA and generate a BIP to try to address that, to prevent that behavior from recurring. Or if the student already has an FBA and a BIP, you're going to go ahead and modify or review to determine, do we need to add anything or do we need to change something to prevent this from occurring again? That also is the third possibility, which you can also address other programmatic changes or needs through review and update of the IEP, again, through a proper CSE process. But if the behavior is resulting from the district's failure to implement the IEP, once we're aware of that issue, you must, as a district, take steps to remedy that. So if we were missing counseling, we need to get that counseling back in place. If we, miss a number of services, we need to look at, do we need to provide compensatory services, and how and when should those remedies be applied? And that is all part of the, review process and addressing the outcome of a manifestation determination. There is not a new category. There is a special category of the presumed student. I call them, the 14th category of student with disabilities, the one who hasn't yet been identified. There are some students who may be in process, meaning there was a referral made or the parents expressed a concern in writing to the student's teacher or to they already made a referral to the CSE or a building administrator, or there's a concern in process and they haven't quite executed the referral, but there was an ongoing process, or the teacher has expressed a concern to their administrator or to the director of special ed about a specific pattern. That's when the district is deemed to have knowledge. The decision about whether the district knew or should have known that the student might be a student with a disability is going to be determined by the district, but these are the factors we look at. So if there's a referral in process, we're going to presume that the student may be entitled to those additional protections which they will receive. The challenge comes up with if they have not yet been determined disabled and we don't have the evaluations completed, how do you determine if it's a manifestation? You're going to make that decision based on the information you have. And then you are going to make a determination. It also means that if you have a student who's in the referral process, you're going to also expedite that to get that done as quickly as possible. But once you have that manifestation determination on the radar, you can't defer it. You have to, unless all parties agree, but you're really supposed to make that determination based on the existing information, which hopefully if these referrals or concerns have been expressed, there is some information upon which you may make that review. What doesn't constitute when the student is a presumed student with a disability? If the student was evaluated, but then the parents, refused special ed services, if the student was referred, but the parent didn't consent to the evaluation, if they were found ineligible, or if they, and just the fact that a student's getting interventions at a building level, whether it's through RTI or your multi-tier support systems, your AIS or building level counseling or building level OT or something, does not automatically trigger that this is a potential student with a disability. Because again, sometimes we have students who may have a short-term crisis or who may be, just struggling with a particular skill where they may get building level services. But basically, if the parents have prevented or precluded the district from being able to provide supports or withdrew consent for services or refused to consent to services at the outset, then they can't simultaneously argue, the student should be protected by the rights of a student with a disability. Our hope is that we don't have a lot of refusals or declinations, but that does happen. And, the end of the day, we recognize that parents have that choice, but we do want to make sure that, we are making those determinations if there is a question raised as to whether or not they believe that the student should be afforded those rights. And that determination about presumed student status is made by the district But again, there always are, you know, options and appeals. If the student is not deemed or eligible for special education, they don't have the same appeals, but they do have disciplinary appeals that are available just like every other student. Special protections. Okay, a lot of questions come up with, can a preschooler get, you know, a manifestation determination? Are they entitled to an FBA and a BIP? The answer is, yeah, they can. They would have the right to the same protections and services. We don't typically have a ton of preschool students, or at least not in my experience, but again, I know that, you know, upstate versus downstate may have a different reaction. But we don't have a ton of preschool students with a disability who are, you know, frequently being disciplined or removed. But if they are, they do have the right to a manifestation. They do have the right to, you know, FBA and BIP, and we should be following that process and monitoring if we have 10 days of removal. Parents who revoke consent for special ed services, the answer is no, there aren't protections because, again, that they're no longer eligible, so those rights and entitlements do not apply. Charter schools are, yes, they are just considered another public school, so they have the same, you know, rights in terms of discipline, manifestation determination. This one is a new one that was added to, you know, guidance that hadn't previously been: virtual settings. If students are facing discipline and they're in a virtual setting, do you have the same rights and entitlements? The answer is yes. And what often in that particular case means we may have to look at, is it appropriate? Is the student responding well to that virtual programming? Are they able to get the supports and services they need? Because that may in and of itself be part of the programmatic review or change if that is not working. Fortunately, we are mostly past that point where we have a lot of remote or hybrid, you know, instruction as kind of the rule. We do have some virtual academies, and we do have some programs that have created an online alternative, which can be helpful, but we still have to look at, you know, discipline and removal rights, which are still the same, you know, regardless of the setting, so to speak. And then private state approved, yes, they are also entitled to receive those same rights and entitlements. So there is no, you know, automatic removal of a student from a private approved program where a student may be placed. There is still the right to due process. There is still the right to superintendent's hearing if we're going beyond 5 days. There's still the right to notice an opportunity to be heard prior to the implementation of that. And I think that it's important that, you know, from a district perspective, we need to make sure that that education piece is happening. And more importantly, the communication between those private approved programs and the school to make sure that those necessary steps are being followed in the event of discipline and removal. And from a parent perspective, to make sure that parents are aware that, you know, they have those same rights, regardless of whether in the private approved school or a public school, to notice prior to the imposition of suspension, in writing, opportunities and rights of appeal, opportunities to question complaining witnesses, and to have the opportunity to present the student's version of events prior to the implementation of discipline, with the exception of if that student has been deemed maintaining them in school is dangerous. The examples that I see most frequently, or where districts have used that, is when the student is posting a you know, a threat that they're coming into the building with a weapon, and, you know, the district may then deem that that conduct, especially when they post a picture of them, I'm giving real life examples, post a picture of them online holding the weapon saying, "See you tomorrow, everybody." So in that case, we did have an immediate suspension, deeming that the student was suspended. We also pursued a red flag, which is a special order where, you know, they would go in and they would remove weapons and preclude the student from having access to them for up to a year, which can be removed. But that's an example of a dangerous student whose immediate presence would potentially be removed. That hopefully is not a regular and ongoing issue, but that's what I want you to be aware of. There are appeal rights, okay? And when you have a discipline challenge, meaning the parents have the right to appeal the decision of, there's two appeals, let me clarify. One is if there is a superintendent hearing or a suspension, there is the appeal through the Board of Education and or to the superintendent, depending upon who issued that suspension, and then up to the commissioner if you wish to appeal discipline from the administrative side. On the flip side, for our classified students, there is the appeal option through of the manifestation determination or the IAES, which is recommended. which can go through your IDEA due process, or mediation, which is also an option. But remember, mediation requires that both parties have to agree to participate to mediate the dispute over discipline, but that is always an option. The benefit of mediation is it's a state-funded program, and there are trained facilitators who are there to try to help bring the parties together, but everyone has to be willing to come to those outcomes. But if there is an appeal filed, you're going to have an immediate imposition of pendency, which basically means even though the student may have been recommended for additional discipline, once the appeal is filed, the student remains in that last program and placement and continues to attend through the resolution of that hearing. The only exception is if there is an expedited removal request to have the student put in an IAES, an interim alternative education setting, where the district establishes to a hearing officer that they believe maintaining the student in that placement is likely to result to injury to that child or others during the course of the appeal. And a hearing officer does have that option of imposing it, and it is something that can be renewed. But again, that standard is pretty high, and it's the expectation that 9 times out of 10, we're probably going to be working through the student continuing in that placement, which is why it's all the more important to look at when we go through the manifestation, not only, developing or recommending an IAES, but also looking at programmatically, do we need to make any changes or supports or services? We also always have the right, with cooperation with the parent, to look for a different program, which may also be something that, if we agree that the behavior is, a manifestation, but we recognize that this is not a program that is capable of meeting the student's needs, the CSE can work together and recommend and pursue out of district placements or other supports and services or consultation or other things to come in and supplement the program. The biggest challenge this year is finding space and finding a program, which has been an ongoing challenge, partly because of staffing, not because there are programs that don't have the capacity or willingness, but because they cannot staff, they cannot open some of the new classrooms. There also is a small hitch of some holdover from kids who continue to attend due to certain extensions of the right to attend beyond age 21, which may be in programs which also are taking some of those spaces as well. But generally speaking, if there is an appeal, there's a stay put right, which means that the student continues to attend. And if that is the case, and that is invoked, the district may also need to look at, do we need to do something different as an interim support to try to make sure that we don't have a repeat of the conduct that resulted in the disciplinary action, or does the student need to make that request for an IAES? The important other piece to note is when there is a manifestation or an IAES appeal, it's expedited, and it's because it's discipline. So if it is correct, we need to get to that decision quickly, and if it is not correct, we need to get to that decision quickly so that appropriate remedies can take place. The nice thing is that in addition to explaining what the laws are, there was some guidance from the U.S. Department of Education about positive and proactive approaches to supporting needs of students. So they offered the system, the explanation, the process, and the Q&As, and also some ideas. Now, the ideas are not as formed as I always like. I mean, I really, want to be able to give everyone, these are the best ideas and this is how it all works. But there are a lot of good federal and state resources to reduce the use of exclusionary discipline. Pages 14 to 16 of that document has a list of about 20 different agencies with links to strategies, videos, tools, training information, webinars, and other resources that can be particularly helpful to kind of open up, new doorways and pathways. There's a lot of discussion about using your evidence-based programs and support. So, also looking at the multitude of student needs. Some kids have IEPs, but also qualify for building level support, because a student with a disability is entitled to access AIS or RTI in multi-tier support systems, as well as their IEP. It's not the exclusion of, they may have both. The only limitation is if they don't have enough space in their schedule, special ed is going to trump, but otherwise we're going to make sure that we provide them. And those targeted supports and building systems can really be helpful to try to minimize or prevent that. Really looking at our school environment and climate. Have we provided education and support to building educator capacities? And are they getting the professional development and coaching and consultation that they may need to have more strategies to both, one, connect with our students and to promote an environment of safety and comfort where students are less likely to engage in problematic behavior, and two, are we also building capacity on strategies and implementation of those strategies to potentially teach a skill, replacement skills, or to monitor the environment and make appropriate adjustments to minimize the triggers that might cause those behaviors. And this is really all about, it's not, behavior is not just the consequence, and that the discipline is the consequence, but we look at what do we do to change that? Because if you're only focusing on the end result, you're missing the point. Behavior supports and interventions start with what happens before the student gets upset. How do we prevent that from happening? What do we need to do? Then we need to have strategies for what do we do in the heat of the moment. Again, that is not the time to say, let's talk about, these deep breathing exercises that you could have done. This is where we want to get them back to baseline, after which you can then provide other supports and services. And that's part of the different strategies and approaches that we look at to make sure that our only response is not exclusion and discipline, that there are other tools. And candidly, there's also a lot of, district level and classroom level behavior management strategies that should be utilized, as part of our whole approach, which we then may individualize for individual students. But this is part of a much broader discussion about the importance of a positive school climate and an understanding that our goal should always be that our kids are in school. And if everyone is focused on that goal, we have a lot more buy-in and consistency in terms of how we are delivering and supporting those students. Specifically, there's guidance on restraint and seclusion. And to be clear, restraint and seclusion are not appropriate strategies for disciplining a student for behavior related to their disability. One, because there's no evidence-based practice or demonstration or report that ever shows that it was effective. What it is effective in doing is perhaps removing or stopping the student from injuring themselves or others. But other than that, that's not going to change the behavior. Behavioral intervention strategies and targeted supports and therapies or instruction on replacement behaviors, those are effective means. Providing appropriate behavior support, appropriate classroom programs and staffing are appropriate behavior supports, but restraint and seclusion are basically just removing the student from the environment, and it does not change or alter it. So we really want to use restraint and seclusion only in the instance where there is an immediate danger to the student or to themselves or to others as a result of their behavior. So if a student were climbing the bookshelf and is threatening to jump, that might be one of those instances where we might need to physically remove them for their own safety. But once we get them down, we're going to A, move them away, and B, try to prevent them from getting back up there. But that's not the typical. Our goal is more often than not to, just remove the safety issues from the environment so that we can just continue to work with the student. Sometimes that does require getting the student to a different location. And there are ways through which we can provide appropriate alternative spaces and services to the students, but it has to be through a process, because restraint or seclusion outside of that process, without the proper checks and balances and using appropriate space and monitoring, is simply, a violation of civil rights. So, speaking of, New York had a law that was passed in August. Chapter 516 of the laws of 2022 rolls off the tongue. But what it basically says is if a student if there is the use of a physical intervention or a mechanical restraint or a timeout room, there is a same-day notification requirement as to when those behavioral interventions are being used, which means that you have to notify the parents at the time. I'm going to draw your attention to the fact that this current guidance is different from what the current timeout room white paper that was created in 2011 by State Ed is, which is it said that how often do you notify? It says it's developed based on the discussion and part of the plan. So right now we know that regardless of whatever prior practice, you need to be notifying parents daily if that's the frequency in which these restraints or seclusions are being used. And we have to have a procedure for that notice, and it needs to be documented. So obviously this may change. We've had parents who are like, why do you keep calling me? I know this is part of the, this is why they have a timeout room, a part of their plan. I understand that, we're working through, we're doing medication adjustments or other strategies, but at the end of the day, this is a requirement, this is a law. So we need to educate our parents and we need to educate our staff that this is what has to happen. Now, there is supposed to be state guidance forthcoming. I understand that it is currently with counsel's office and is apparently being reviewed for finalization. But until that comes out, right now districts have to have that that same day notice. And if you can't get a hold of the parents because they're not responding or they didn't, confirm or email, you have to document that response and make sure that we're notifying the CSE, because again, where we have restraint or seclusion used on a student with a disability, it raises the question of, is that part of their appropriate IEP services and plan, and are we following those plans and services, or was this a one-off emergency removal? Generally speaking, just so that you know, there is a prohibition in New York State on corporal punishment. There are a number of different provisions. There's a regulation at 19.5. The only exception to the use of, and it's not corporal punishment, but limited physical force can be used to protect yourself or to protect others from injury or the property of school, or to to remove a student whose behavior is interfering with the orderly exercise of instruction. However, I always say we are doing everything we can to keep our hands off kids. I encourage district staff to look at children as if they were a 6'6" football player. And if you wouldn't pick them up or move them, then don't do that. Do everything else you can to try to strategize, to remove, to eliminate, risk factors, to, follow the behavior plans, to give, consideration to your contact level. Are you at eye level with the student? Are you communicating in an appropriate voice? Are you minimizing communication verbally if that's an issue? Following those strategies to try to prevent the need to physically intervene with students. There's also additional regulations that go through aversive interventions, and there are also aversive interventions are specifically addressed in the 200.22 regulations of the commissioner, which relates to special education programs and services. But end of the day, it's very clear, and this is the part I want to draw your attention to at the bottom of the screen under 19.5. These prohibitions do not include interventions such as voice control, loud, firm comments, time-limited ignoring of certain behaviors, token fines, brief physical prompts to interrupt a specific behavior. So for example, if a student is, constantly, hitting and, someone just sort of gently, puts their hand on to remind them, keep your hand low, that's fine. If you're holding it down and preventing movement, that's a physical restraint, but or a hand over hand is a perfectly appropriate thing. So if that's part of how the student needs assistance, that's not a punishment or a corporal punishment. That is an instructional strategy. But again, there's got to be some freedom of movement. If you're, holding them in place and gripping their hands and it's, causing pain, then that's not an appropriate intervention. That's where we're crossing over to a physical or mechanical restraint. End of the day, we also have certain things that may be medically necessary. Some students who have significant seizure conditions may wear a helmet. You can use a helmet as a preventive measure. It should not become a consequence. It should be, something that is part of the ongoing treatment and protection as opposed to a reaction for the student. And those are kind of like the basic parameters. The 200.22 emergency interventions basically mirror, this is the special education regulations, mirror a lot of the 19.5 regulations that apply to all students. And it really talks about the emergency use of reasonable physical force, but it is certainly encouraged that this would be used in very limited circumstances, and recognize that this is not a substitute to appropriate behavioral intervention or management or appropriate programming and staffing, that this is really more of that emergency response. And now New York requires that daily notification or notification at the time of the incident to the parents if we have used a physical intervention or a timeout room. Speaking of timeout rooms, if a student has a timeout room policy, if a student has timeout room as part of their behavior intervention plan, the district must have a policy in effect that identifies that they are using a timeout room that really has the specific features and is designed to be used as a timeout space, that they're only used in conjunction with the BIP, or there's a very limited exception on an emergency basis, but if you're having 3 emergencies with the use of a timeout space with a student who's not classified, then you're running into an issue. It should not be the default, it should be the emergency circumstance. And districts have to have policies and procedures for the use of that room, including monitoring. If a student is in the timeout space, there needs to be constant visual and auditory monitoring of the student. They can't have a locked door. They must be able to open the door from the inside. You have to use normal, heat and light and temperature. It's okay if you modify that as part of the room. Like sometimes there are blankets and dimmer lights and things like that, but that's part of the design of the space, but you can't turn off the lights as a means of altering the space and making it unpleasant. So and it shouldn't be excessively cold or excessively hot. It needs to be the same temperature and parameters of the rest. And you have to have a limit as to how long a student may be in timeout space as part of your behavior intervention plan, as well as a district-wide policy, because it does come to a certain point where if the student has not, regrouped or recouped and is not able to return, maintaining them in this isolation may not be doing anything to facilitate their improvement in any way, shape, or form. So, and most importantly, if you're using timeout room, it's not just about using it, it's about monitoring the efficacy. Is it working? Are you seeing that the students' behaviors are shorter, they're able to regroup faster, they're able to modify and adapt, that quick break is helping? Because if it's not, then again, the question comes down to, if it's not working, don't keep using it. We may need to look at it differently, or look at how we're using it, or under what circumstances we're using it. Sometimes we have districts that use their timeout space as an alternate, break space, and I think that can be confusing for kids. Because if I go here when I'm frustrated, or I go here when I'm not frustrated, it doesn't necessarily send the same message. So looking at how are we using that room, and is it clear what the purpose is, and are we reinforcing the student's positive use of that, time and space, and reinforcing that, we are only using it when it's absolutely necessary, as opposed to, it might be, a break or a convenient time for the student, but we still need to look at, is it working? The IEP has to specify that the student has the timeout room as part of their plan and the maximum amount of time. So you have a district max, but you have individual student max, which is going to consider, the age of the student, the nature of their disability, as to what's an appropriate amount of time that they might be in this space. And again, you also want to look at making sure that the space use is not becoming the student's escape mechanism to avoid access or demands or instruction. And then prior to initiating a behavior plan, there's a requirement that parents are given the opportunity to go and see the space. They may or may not choose to do so, but you must offer that opportunity to see the space and a copy of the policy. And the space itself has to have certain parameters that must be met. It needs to be safe. It needs to be, adequate, height, light, space, heat. You may need to cover features that could potentially injure someone, clean and free of objects. Some of them will have minimal furniture, some will have no furniture, but end of the day, it needs to be something that is appropriate for the students and will keep them safe. And oftentimes we may have comfort areas where they have changed lightings or certain items that may be there of comfort or, support for the student, but you have to make sure that those things are safe and appropriate. And again, most importantly, cannot lock, cannot, ever lose visual or auditory communication and sight of the student. Okay, other guidance docs. So again, discipline and removal has been pretty much the biggest focus of the guidance so far. This year, once again, we had a passage of a last-minute late-breaking, legislation that allowed for the continued option of students who could potentially return to the 22-23 school year due to the impact of COVID-19. So if they turn 21 during the prior year, they may be eligible to come back for an additional year if it is necessary to complete their IEP and receive those services. This is really where, I look at the most common concerns or requests that were precipitating requests to come back, and it really often had to do with transition planning and programming, and making sure that students had access to the programs, the services, the community-based intervention, vocational opportunities, and really being out and among the community. And those are the issues where we've struggled when there was still restrictions or limitations in terms of how some of our other partner agencies were functioning at half-mast or were not fully functioning. And that really did impact some of the ability to implement all of our transition planning and supports. Every once in a while, they kick out a new updated medication management guidance for schools. They just issued it this month in October. It basically covers medication administration and safety requirements. So when can a student have medication at school? What's the requirements? What types of level of functioning does the student? Are they independent, meaning that they can self-carry and self-administer medication where it's not going to be documented or monitored by the district? That requires a note from the student's physician, a sign-off by the parent, a determination by district staff, typically your medical director or your school nurse, that'll deem that we do believe that the student is able to identify the purpose of using the medication, the circumstances under which they need it, and also understands the safety provisions. Many of our independent students is really related to it's related to albuterol inhalers or epinephrine pens or glucagon auto injectors for diabetes, or there are other personal care items for managing diabetes, but that is circumstances where they can be deemed independent. The other two categories are nurse dependent, where all medication or treatment must be handled through a nurse because the student lacks the capacity or the ability to make those appropriate decisions, to know when they need it, why they need it, to adhere to the time schedule, or a supervised student who can direct someone to facilitate them accessing that support and service, which means that it might be done by someone who is not the school nurse, but who has received certain training. So for example, we have sometimes where the supervised student will have an emergency medication that may travel with them to a sport event, and there may be training for the staff member to provide that if it's necessary. And again, sometimes it's the glucagon, sometimes it's a migraine medication or an ibuprofen, but it's got to be consistent. There has to be documentation. At the end of the day, we don't really just want kids carrying medications around school. They have to go through a process, and that's for the safety of that student as well as others. Confidentiality about medications is important. And, we also have, while districts are not subject to HIPAA, generally, there are certain provisions under which, but FERPA also provides the same confidentiality about medication and health and medical issues for students. And there are some specifically confidential areas that we have additional protections and obligations for, but generally speaking, medication or treatments should not be public fodder. It should only be, those who need to know and have that information. They updated the opioid overdose prevention section. There are some additional options districts could choose to have the opioid overdose status. They can also get a non-patient, order available and administer with the appropriate training and guidance, or they could, simply have an emergency process as to where we go. And there's some changes on the clarification of training of unlicensed personnel to administer glucagon. Basically, districts may, but are not required to have the nurse or the PA or your physician train unlicensed personnel to do that. However, in many cases, we do feel that they need to be able to do that in order to provide that support and security. So most districts will do that. But 921 allows it that it can be done, but some districts will still stick with everything going through the health office or the nurse's office. But if you do provide that training, it has to be consistent with the commissioner's regulations, and it's basically, you have to have performed the training and seen the video, and that you've basically assured the nurse to the extent of their satisfaction, or your physician, that that they are capable of administering the medication at the right time, at the right circumstances, and that there is also an order on file. The parents have agreed to that, and it would be administered on school property or at a school function. Again, a lot of these may come up in particular when we have field trips or events that happen outside of the school day, extracurricular activities and all. Auto injector devices, again, this is another where districts are permitted to purchase and utilize epinephrine. We have a lot of individuals who have had food allergy or extreme experiences, and the ability to, administer epinephrine on a non-patient specific basis is something where they have allowed that, where they've had appropriate training. Basically because anaphylactic symptoms happen quickly, and not having the ability to, determine that, they have decided that it's better to kind of act on the safety provision to emergency intervene and hope that we are going to prevent the student from, having that reaction. Ideally, if they have their own epinephrine pen, we'll be using that, but there are circumstances or emergencies where that may have been utilized because someone was having their initial anaphylactic reaction to a condition or a medication or a exposure that previously was not known to have been an allergen. As with every year these days, we have our annual COVID updates on what districts are and aren't required to do in order to comply with the current guidance from the CDC and the Department of Health and State Education Department. Basically, most of the restrictions have been, repealed. There's still, you can, but you're not required to. We have lessened a lot of those burdens. However, I do want to remind everyone that if you've been watching the news, and we all have, there has been an escalation, and now we have the triple threat of, the flu and COVID and a new COVID variant. So we have to be mindful that this is the current guidance, but at any point in time, should our circumstances change, then there could be new guidance that we would have to jump in and follow. Right now, one of the biggest issues are younger children and RSV. So you might also have some questions and concerns coming up from your preschool programs about safety and security. Right now, there are no requirements for these, but on a voluntary basis, there are certainly the options of parents can send their children with masks and other things there. No one is going to be prohibited from utilizing additional protective measures, but it's no longer required at this time. But again, it all depends on the way the world turns, because tomorrow it could be a different day. The state education department adopted updated regulation. The terminology is now no longer emotionally disturbed. It is now, emotional disturbance instead of, is now emotional disability instead of emotionally disturbed. And, it's basically a change in title. I know that we had all hoped that there might be a change in the language or the details that leads to understanding or classification, because there are some, questions about where certain conduct that might fall under, such as oppositional defiant disorder and things like that. And it's a question of, is this maladaptive behavior, is this not? But the title is what's changed. There is no obligation to go back and revise all of your IEPs if they currently have the prior term, but going forward, that change should be noted. And again, it's a matter of, educating people that the category has changed, but the basic eligibility criteria remains the same. Okay. So one of the other issues that came up and is really related to COVID is that we had a ton of issues and concerns that really came up about who is getting home hospital or homebound instruction. And during COVID, we had, when districts had sort of the option of go to school or stay home, there were many parents who elected to stay home. And then in subsequent years, were still concerned about COVID safety and, did not want to send their children, but there wasn't necessarily an automatic prohibition that they, were unable to attend. It was more of a preference issue or a potential medical issue. And between the districts and parents contacting the state, they said, you know what, we recognize that there's a category that is not yet really being addressed. And they did something which I actually think has been really helpful for everyone, because it really set forward a much clearer path. They created a new regulation, 100.22, which really talks about provisions for homebound instruction when it's an issue such as the child is immunocompromised, or there is a request for home instruction related to the student having health or medical issues that might lead to removal for more than 10 days in a 3-month period. And they've established new requirements as to how that determination is done, and it requires more formality. One is it can be provided to students let me just step back. Home hospital instruction 175.21, that applies to kids who are in a hospital or an institution for care and treatment. They might be in a rehabilitation facility. They might be in a drug rehabilitation or a OASAS facility, Office of Substance Abuse and Office of Substance Abuse, I can never get it, OASAS, basically Substance and Drug Abuse Program. And so there, those individuals who might be in the facility are still entitled to receive education, and that's pretty straightforward. But when you have kids who are not in those institutions or who are not in a hospital, there is the category of, well, what do we do with them? There's the CSE recommended, where we do have sometimes where, because of the nature of the student's health or medical issues, they may be placed on home or hospital instruction as a measure to support and accommodate that student. But now there is this new category for when we get a request from parents to make sure that these students are going to be continuing to learn the mastery of standards during a time which they are unable to attend school for periods of time. But there's more specific information than we've ever had, and it now creates this protocol. One is we have definitions. Who's a tutor? What's your district of residence? District of residence is relevant because sometimes we had parents who had children placed at a private school, but end of the day, your district of residence where you reside is always potentially responsible for any home hospital or homebound instruction requests. So sometimes people are like, well, no, they go to this private school. Shouldn't they be getting alternative instruction from that district? Nope, always goes back to district of residence. 2, now adds a required medical verification from the child's treating healthcare provider as to why they're recommending or requesting home, hospital, or institutional instruction, as well as a written request from the parent. So there's more formality to it. And where I've seen this come up is we get, and again, I'm speaking with, 70 districts, lots of BOCES. Sometimes we get a request that says student is anxious, provide home instruction for the year. So to me, that doesn't really provide a lot of information to work with, and B, there's really no plan or indication as to what we're going to be doing or how or why, or is there any plan to get the student back to school? So now they require a more formal documentation, which specifically requests information, and there is a time frame for review within 5 days of receipt of the notice and the request, or the documentation and the request. And now my favorite part is we invoke the medical director, which really, I always felt that trying to make these decisions about homebound instruction for medical reasons should have involved school, physicians or medical directors or, the school health services. I have always, in my districts, encouraged if they're doing homebound and home hospital instruction policies that they include that as part of their review. The state has adopted that. Yay, I love that. And they also created an appeal process where if you disagree with the decision, if the homebound instruction is denied, there is an appeal process. And they also identified things like the minimum number of hours of instruction, which right now is 1 hour for elementary, 2 hours for middle school, but hang on to that. When we get to another slide, you're going to see that there's a change coming down the line. How we are modeling that plan, location for where those services are there, and developing a specific instruction plan, which identifies how the student will continue to maintain academic progress. So they adopted it, and then they added some additional provisions which are not yet in effect, one of which was minimum number of instructional hours will move to 10 hours for elementary and 15 hours for the secondary level as of July 1, 2023. And there will be subsequent amendments to 175, to change to those hours, but that's a big change. That's an increase of the number of hours for both elementary and middle by 5 hours per week. There is a provision under which you might provide less if there is medical documentation in the parent request. Because so, for example, if you have a student who has very limited vitality or is, very, very ill, undergoing chemo, they may not have the ability to sustain the 10 or 15 hours a week. In those cases, you may use less, but it should be reviewed on a regular monthly basis to determine if we are at a point where we can increase or go up to the minimum. Now, these are the minimums. You can always do more, but you cannot do less. Right now, it's 5 and 10, but July 1, 2023, it becomes 10 and 15. The next part is that, of course, as soon as we pass a regulation and an amendment, we have an amendment to the amendment. So as of September, we got the feedback because the original regs were adopted on an emergency basis. So they were adopted in May, went into effect July 1, 2022. And then they got the comments and feedback in September. And then they said, oops, you're right, there's some things we need to fix. So one is that when the parents submit notice and request for the home hospital instruction, they need to also submit the medical information, including a release, which is the new part, a release to allow the school physician to be able to communicate, or the school medical director to be able to communicate with the treating provider that is making the recommendation for this home or hospital instruction. That's a big thing, because where districts have struggled previously was when we get a note, but then we have no capacity or ability to engage. If it's not a note about a medication or a medication treatment, you know, HIPAA has a provision where you may go back and reach out to that provider to get clarification. When it's not about that particular treatment, then you don't have that automatic release. This now requires that we do have that release as part of the application, and failure to provide that release will result in an automatic denial for instruction. The other thing they did was they extended the appeal. You had 5 days to appeal from a denial, and now it's 10 days, which just basically gives people more time, especially if they, you know, are looking for more information, or, you know, or waiting on something else. And it also clarified, because there was a lot of questions on who is involved in and what does that instructional plan look like. Ultimately, districts need to consult with the parents and get the input from the parent and the student and the teachers and the providers, but ultimately the final decision about the plan as to location and how instruction will be provided and through what method is determined by the district. But again, we always have the option of, you know, trying to reach a consensus, which is always my favorite word, to come to agreement on how to do that. And again, this is also something that we might review and revisit as the student is on, you know, a home instruction or homebound instruction over a period of time, because needs and support needs may change. Or also, I always want to look at, when do we bring them back? Because homebound is a very restrictive environment where you're away from others. And it can be home tutoring versus homebound instruction. So sometimes it may be remote, or it may be at an alternate location. But end of the day, our goal is always to give kids the access to, you know, the typical school environment amongst their non-disabled peers to the greatest extent appropriate. So we're always looking to get them back in. Okay, transition planning, and we're coming to the end, I promise. You know, really thinking about our post-school outcomes, vocational training, and different things. And I'm really gonna flood your minds with an upcoming thing on legal rights of students with disabilities over 18. So there's been some updated guidance that was issued. One is 2020, which isn't as new, but it's a good guide about, you know, different post-secondary options and employment, really talking about how we need to be setting high expectations for our students, making sure that our transition planning incorporates the expectation that they will have, you know, additional activities or vocation or employment or independent living following their exit from school, and that we are building all along. Our transition plan is dependent upon building those expectations, so the students will have that planning and those contacts in place in order to support that transition. I am a stickler about self-advocacy and being able to recognize and advocate for yourself. I always say special education is a triangle. First thing at the bottom, we remediate a skill deficit. If it doesn't exist, we're going to remediate it. The next thing is we're going to teach you how to use compensatory strategies. Some things we can't remediate. We can't make your memory better, but we can give you strategies or teach you to write information down. Then we teach you accommodations. How do you use those remediated skills or compensatory strategies in order to access and demonstrate your knowledge? And last but not least, at the top of the pyramid, the I, the independently being able to utilize your accommodations, compensatory strategies, and remediated services. We have to always remember the top of the pyramid is the I, and making sure that we are building student skills as we go along to help them be involved. Because the reality is, when kids exit our schools and our programs, they go out into a world where your child's like doctors, or they're no longer a child, but when, you know, they're an adult, their doctors aren't going to answer your calls or questions. Their boss is not going to accept, I need to give them, an accommodation. They're going to say, my employee can talk to me, I'm not talking to you. And when they go to college or university, depending upon where they're going or any other kind of higher education, some programs have a disability support services office, and others simply require that the student negotiate on a case-by-case basis with their individual, teachers or aides or support staff. And that is an important thing to keep in mind, that often we don't focus as much as we need to on building both student awareness of their disability and how it impacts them, and then self-advocacy to be able to articulate what they need, why they need it, and how they need it, and when is it appropriate to request those supports and services. Another new guidance that came out was this really good framework for community engagement. There's a lovely chart in it that talks about the interplay between different agencies to support competitive employment opportunities for individuals with disabilities. It talks about how special ed and related services tie into that, but also that there really needs to be that connection to the other agencies and supports that are going to facilitate that individual's transition to adult and community living, as well as other higher education, and really gives a very nice overview of the interconnectedness. The only challenge I remind everyone of is many of those outside services are voluntary, and therefore the parents and the student have to agree to participate and to follow through on that. But it's really important that we be educating families about these options and resources and doing everything we can to connect them. And sometimes they aren't going to come to the one-time, training that we may have. So let's look at other ways to provide that broader exposure and information, do parent information nights, do pamphlets and leaflets, provide additional resources, offer to, schedule group meetings with parents for graduating students or exiting in the next 2 years to really continue to provide the information about these other agencies, which will become the lifeblood for these individuals when they exit the school system. Schools have an affirmative obligation to find, evaluate, provide, and deliver services. The rest of the world waits for you to ask, and we need to be mindful of that and make sure that they are prepared for that support. Okay, now my favorite topic, rethinking guardianship at age 18. Okay, this has been an ongoing shift, and candidly, I will admit I am a member of the Shared Decision-Making Task Force for New York State, which really has been an advocate in pushing forward this idea of shared decision-making for individuals with a disability instead of exclusively removing their rights to make decisions by applying a guardianship. What really has happened is there has been an amazing change and transition over the past 5 years, partly due to some solid evidence from a pilot project that started out of SUNY Hunter CUNY College, as well as some other important agencies. But we really have gotten to a point where the traditional guardianship at 17A, which you apply for as soon as the kid turns 18 so that the parents can then make decisions, fails to recognize that many individuals with disabilities have the capacity to make decisions. They might need some support, they might need some guidance, they might need information, but we don't need to strip them of their civil and legal rights in order to provide the support or structure that they may require. And so there has been a lot of pressure on parents that are being told or had been told historically, you got to get a guardianship. Your child has a disability. If you don't get this, then they're at risk of losing their Social Security benefits. They won't be able to do these things. And many of that myth is not accurate. There are many different supports and strategies that are available that will allow parents to have those supervisions or supports for certain activities, such as a power of attorney or a healthcare proxy to continue to allow them certain access to medical records that facilitate or support a decision, financial trusts or special needs trusts where monies could be set aside exclusively for certain purposes, special or designated accounts, and using representative payees or other payees to facilitate money management. But at the end of the day, we don't need to restrict and eliminate rights of individuals with disabilities because they happen to turn a specific age. We have the capacity between shared decision-making as well as these other measures to provide the support and structure, but still allow autonomy and decision-making authority for are individuals with disabilities. And, you know, the reality is everyone gets assistance on decision making. If you have, you know, I was just thinking, I got a pair of shoes. Do I like these? Should I buy them? I ask the person standing next to me or the person shopping with me, and they may weigh in. I've just had shared decision making. I got an input and I considered it. Whether I took their advice or not depends on how cute the shoes are. But end of the day, you know, that's really where we're looking at it. So we all do that. And, you know, there's no reason why we wouldn't afford those same rights to individuals with disabilities. Okay, so July 26, 2022, the governor signed into law a new chapter 481, which adds a new section to mental hygiene law, Article 82. And it now recognizes supported decision-making by people with, you know, intellectual, developmental, cognitive, and psychosocial disabilities. In other words, people who have disabilities that might otherwise impact their, you know, decision-making, but not their capacity. And that's the important distinction. It recognizes that everyone now has the right to make their own decisions, and that the ability to do that is critical to, you know, autonomy and self-determination, to have a role and a say in your lives and what is going to happen to you, to be able to weigh in or to make that final decision with the information that's provided. And that really is an empowering factor for a number of individuals who, you know, as kids get older, I'm always looking for them to attend the CSE meetings, to be part of that discussion, because this is your life. And sometimes that's not as common. And I think when parents are not including the students because they're concerned that we're going to talk about sensitive issues or we're going to talk about, you know, their needs or their disability, we absolutely, as a committee, can modify the manner and the content of the discussion, but they should be a part of it because this is their life and this is what they will be doing and will need to know and understand going forward. And so the supported decision-making gives individuals with disabilities kind of a team and some parameters to help them pick trusted people that they want decision-making support from, and it's a less restrictive alternative to guardianship. So I'm going to shift over to the specific forms that there's now parameters about what this guardianship shared decision-making agreement will look like, what the, you know, the content and the provisions are. I just highlighted it directly from the regs. I'm not going to give a full overview of it, but, you know, there's very specific elements. OPWDD has been directed to issue regulations within 1 year, and that is supposedly in process to provide more specific guidance on that. And then this regulation goes, this law will go effective, you know, 90 days from the date that that regulation is issued to monitor. And it basically recognizes, and this is a very important distinction, the capacity to enter into these supported decision-making agreements absent, you know, clear and convincing evidence. The reason why people were always hesitant to accept or to not do guardianship was they were concerned that no one would recognize that an individual with an intellectual or developmental disability would have capacity to enter into these agreements. This new law allows and recognizes that, which is a huge step in the right direction. So let me tell you about supported decision-making and how that goes about. You can check out all of the information at CUNY Home, which is the Hunter College. They basically did a 5-year pilot project. They've had consultation from attorneys, disability advocates, special needs attorneys, school district counsel like yours truly, judges, surrogate courts judges, and individuals who represent those with, you know, guardianship presently, as well as individuals who previously were under a guardianship and who have since been removed and who are now making those decisions independently, which I think their voice is some of the most valued as to how important the decision-making process can be. So it is now recognized. There are 11 states that specifically recognize the shared decision-making agreement. New York has added to that, so we should be up to 12 now. And it's basically an alternative to the 17A guardianship process where, you know, basically you become a person who has no decision-making authority, no status. All decisions are made for you by someone else in lieu of your ability to have direction and the dignity that comes with being able to be part of those decisions and to direct your own future. There are facilitators that are part of this process, and they are specially trained to work with individuals with these disabilities. They're, you know, social workers or community agency providers. They're individuals who treat with or work with individuals with disabilities. And so they have an understanding and a reflection process that works for these individuals. First, the process really begins with identifying who the person trusts, who they are interested in having be their support network. Then we work with developing tools for the individual as to what they think they need and how they might need that. And then we work with the people who they've identified to train them on how to provide the supports and yet allow the individual with the disability to make those final decisions and participate in those decisions, but still be the ultimate decision maker, and that they have that legal capacity to make those decisions and to have their decisions recognized. It's no longer a presumption that you cannot have capacity simply because you have an intellectual or developmental disability. So just to give you a sense of the timing, it usually is somewhere between a 9 to 12 month process because there's a lot that goes into it. And so I just kind of broke it down what the typical process has been. You know, the facilitator meets first with the decision maker. That's the individual who's now 18 or will be turning 18 and is looking to have this process recognized and in effect. So they make decisions about what they need, how they might need this, what kinds of things that they want insight on, and who are the people that I want to hear from. Who do I want to be part of my network, and to what areas do I want them to be involved in? Then they're going to go ahead and connect with the support team that the decision maker, that's the individual, identifies, and help educate them and reposition them from making decisions and recognizing that we are now going to shift that decision authority back to the individual, but you're going to give them information. We will let them make their decisions, but you can inform them, you can guide them, you can provide them information, but at the end, they still will make that final decision. And then they actually negotiate a written agreement, which really spells everything out in writing, and it makes it very clear what those process is, what issues and who's helping, and on what level that assistance is, but still retains the decision-making with the individual with a disability. And then this particular project gives 6 months of follow-up to check in, to review, to make sure any questions or tweaks or concerns that are happening, you can still go back and revisit. This is really a wonderful alternative. We've been getting a lot of incredibly positive feedback from parents and individuals who have gone through this process, that, you know, they never realized that they were stripping, you know, their child's rights. They just thought that this was necessary for their protections and supports. And the reality is that we can provide the protection and support, but also afford dignity and decision-making for individuals with disabilities over the age of 18. And this is a critical step in both changing the conversation as well as making sure that we are empowering individuals to be part of the decision-making process and giving them that option. And now that we have New York recognizing that this is a valid alternative and less restrictive, and candidly, we've had a lot of recognition from surrogate judges saying, now that I know that there are other options, they're looking more critically at 17A guardianship, because they really want to know, was there no ability? Is there no capacity, as opposed to, you know, working out some of these alternative arrangements for a shared decision making. And this is a huge step, and it really acknowledges that we should be working on the concept, just as with education. All students can be educated and benefit from programs and services. All individuals who become adults still have the capacity and the ability to be part of the decision making and to be empowered by their authority to make those decisions and choices in their own lives. So there we go. Any questions? Okay, so now I'm going to exit the slide share and hopefully pop back up on screen. And if people have questions, okay, I see that there's a lot of questions which I didn't get a chance to get to, but now I'm going to hop on.
Hi, Tara. Yes, thank you so much for that presentation. I do have a list here, 1, 2, 3, 4, 5 questions, and I will just start at the top. It says, can a CIP?
I believe that should be a BIP, a behavior intervention can be initiated by a district without a manifestation determination. Sure, you can always develop a BIP and after an FBA if there is a need for that student to have those targeted and individualized behavior supports. Oftentimes we'll have worked through classroom behavior management, school-wide behavior management, and then determine that the student still has more specific needs that need to be more individually targeted, and that's when you will develop an FBA and a BIP. You have to create one if you're through the manifestation process. You may always create one other than that if it's necessary and appropriate for the student.
So this person who asked the question, they said that they did mean a CIP, a change in place.
Oh, a change in placement. Yes, you can. I mean, again, anything can be agreed to by the parents and the district in terms of a pursuit of a change in placement. You know, just as the same as you can always have a CSE meeting to come back and revisit and amend an IEP or a program. On the flip side, you know, it is something that we need to either come to agreement on, or there's a recommendation made, and the rights of, you know, the right to dispute that recommendation is always an important part to it. Our goal is always to hopefully reach to consensus where we are all in agreement that we need to look towards X, Y, and Z, looking to the right program, looking to these other features that may not exist in the current program, and then move that forward. Okay, next question is the quality of the FBA left to the discretion of the district. Well, the quality of the FBA must comply with the regulations at 200.22, which does require that you have information and data over a period of time that will reflect the nature of the student's conduct, the frequency, latency, and duration of the types of conduct that are occurred. You know, develop a hypothesis as to why the conduct is occurring and what things are reinforcing those behaviors, and then think about what would be the necessary support or instruction or replacement behaviors or modeling or environmental changes or physical changes that may be necessary in order to facilitate a different outcome or a different behavior, or to help the student extinguish this problematic behavior and replace with either a pro-social or a proactive behavior or something that is less problemsome. And that's all part of that process. You have to meet the requirements that go into it. To me, a good FBA does involve multiple weeks of data collection, and it usually is, you know, a 10 to a 20-day period in order to have a reasonable amount of sampling of information. There are times where we are using data that that is existing because we have to create an FBA or a VIP under the immediate circumstances of manifestation, but there's nothing that would prevent you from then coming back and getting updated data based on the interim plan and then revisiting it and revising it as necessary. Because again, sometimes when we're developing an FBA and a VIP in the immediate time frame, we have the current issues, but that may not be a global perspective of all the areas that we might want to target now that we are developing that plan. So you may look at what you need to do. What if an I'm sorry, what was that?
I was gonna say, I have a question here. It says, what happens if the district does not notify the parents when a physical restraint is used?
Well, that is a good question that we're still waiting for the state education department's guidance on. I suspect that the failure to provide that notice is, you know, a potentially an issue that can be complained about, and that there may be some follow-up by the state. My reaction and my response is districts should be proactive, even in the absence of that guidance, to make sure that they're following and documenting that notification. And, you know, again, there's also an education piece about what is or what is not a physical restraint versus a hand over hand versus, you know, a guide. And so making sure that we're also using the same terminology and understanding as to what is or what is not. But end of the day, timeout room space is pretty straightforward. But the physical restraint, again, I always say that if you're walking down and the student grabs your hand and you're holding their hand, then you're walking hand in hand. That's okay. If you are pulling them and they are dragging behind you, that is not a walking hand in hand. That is a physical restraint. And, you know, if there's no voluntary movement, to me, that raises that potential level. So what if an IEP is not sufficient to address the student's needs prior to the behavior? To me, that question really comes down to, you know, IEPs are changeable documents based on the changing needs of the student. If the student is, you know, struggling, if there are new issues that are developing, if there are new problems, we need to go back and revisit that. Not every problem will automatically, you know, change an IEP. Sometimes it's a short-term situation that may resolve. Other times it's something that we are seeing an ongoing issue and that may require a revisit of the IEP. When we come to a manifestation determination, you're looking at the IEP as it exists and the records and reports in the file and the observations of the teacher and the input of the parents at the time of the incident. But there are often times where new information comes forward after the fact which you then have to review and consider and go back to the IEP or program and service and say, does this change what the needs are? Does this change what we should be doing? So, if you get new information or if you have new concerns, you certainly cannot ignore it. You do need to go back. Okay, does the district have to expedite the referral process if manifestation determination meeting is set during the referral process? Yes. One way or another, as soon as there is a discipline on the table, you're automatically converting to expedited. And it's because it's in the regulations at Part 200. It's not a, so if the referral comes in after the fact, but discipline is on the table, expedited. If the referral came in right before, and then discipline is on the table, expedited. So one way or another, you're still going to expedite that process, which means it's going to truncate the evaluation timeline to no more than 15 days, and then you have to have the meeting within 5 days. So it basically knocks it down to about a 20 school day process. And that really is designed, I'm sorry, 20 and 5. So it really is designed though to ensure that we have a timely decision on programs and services, but you still are going to have to do the manifestation determination at or by day 10, even for a presumed student. So you will make your decision based on what you have, but it doesn't necessarily mean that you have completed the entire evaluation. You might prioritize knowing that you may need to do a manifestation to get, your psych ed or, some other aspects of the evaluation done as quickly as possible within that 10-day period. But at the end of the day, you're going to meet on or by day 11 with what you have to make that determination. There's a letter that was issued by OSEP, Office of Special Education Programs, called Letter to Nathan, N-A-T-H-A-N, which really talked about the decisions for eligibility for a student prior to determination of eligibility when you have to do those manifestation. And people said, well, can't we just defer until you complete the evaluation and eligibility process? And they said, nope, no, you may not. So you need to do that as it goes. Okay.
I'm going to jump in with a couple questions from my end, just so we're balancing them out.
Absolutely.
This question said, is there anything in the regulation that states how often a parent must provide a doctor's letter regarding continuing home instruction when the medical condition is ongoing and the district knows that the student's medical condition is not going to change?
Well, the answer is it's not expressly spelled out, but I do think that districts may include additional provisions that would recommend that there be regular updates. There are certain conditions that, may not ever change. I mean, you may have, if you have diabetes, even you could have sometimes where it's well controlled and other times where it's not as well controlled. You still have the diagnosis, but the nature and how it presents may change at different points based on the student's growth, their response to different, medications, how things are going. So you may need to get an update as to where the student is now with that condition, as opposed to, the presumption that, well, you have this condition, you always presume the worst of it, because that's not always the case. In the same way, we have many children who have mental health issues, depression and anxiety, but where they are on that, spectrum of the level of anxiety really may change. And it's also a question of being able to keep current on what's going on in terms of outside treatment. How are we potentially able to pair that with inside supports to try to make sure we are globally approaching things from the same perspective? So you do need to have current information in order to do that. There's no set date by which you have to do that, with the exception of if you are getting less than the minimum number of hours received, that requires a monthly update. To me, I think that, if you have a student who's on a longer term home tutoring, home instruction, there should be some routine review to make sure that we are only doing that so long as it is absolutely necessary for the student, because districts can be a very accommodating environment. We could do a modification of the length of the day. We could do an early departure or additional breaks during the day. We have some students who may even have, the opportunity to go lie down for a period of time if that's something that they need within the course of the day. Will it impact the number of courses or credits that they may take? Yes. But if it's necessary to accommodate their disability at the time, then that's what we're going to need to do. This is also why kids with disabilities have, the opportunity to continue up until age 21 or longer based on certain state, changes on a day-to-day basis. So it really is recognition that, yes, we do understand that you have this condition, but just like 504, we still have to do periodic updates, and we need to do reevaluation or determine what information is needed. Same thing with IDEA. To me, when you're doing these homebound instruction plans, it's, you know, similar. We need to keep going. We need to keep updating. We get progress monitoring every, you know, quarter from students who are in school. And when students who are out of school, you know, we probably need to have some updates on a regular basis to, again, make sure that we are not excluding a student for any longer than is absolutely necessary. Okay. Could a Good Samaritan law come into play if staff member other than the nurse administered but did not receive training? Yes, but I really don't, as a, you know, as a school council, I never want to have to rely on that. The better course of action is, you know, we can provide that training. It's simple, it's available, it's available through, you know, virtual training, and then the nurse can sign off. I would strongly recommend that we do that. And I think most districts do want to have, you know, staff available and trained. And again, that option is only when you don't have the medically trained staff immediately available to administer it. And again, usually these are really where we're talking about emergency circumstances, where time is of the essence and a prompt, you know, action is critical. I think that, you know, are you likely to have a parent who's going to sue you if you administered a life-saving medication to their child? Probably not. But end of the day, as an attorney, of course, I have to advise that you want to make sure you have the necessary training in order to support that. But I think that most districts have, you know, leaned towards having additional staff trained for those emergency circumstances, simply because we have a lot of kids who have a lot of, you know, medical issues, and that's just part and parcel of our daily school lives, to make sure that we have the support and system available to intercede and to support them if the crisis arrives. Can a parent bring a lawyer to the meeting when the student has a 504 plan? Well, there's no prescriptive list of who attends a CSE or a 504 meeting in terms of, you know, counsel. But generally speaking, if the parent is looking to bring counsel to the meeting, then they should notify the district so that the district can arrange their own counsel to attend the meeting as well. And at least from my perspective as a district counsel, my first thing is to get the contact info for the parents' counsel and call them up and say, what's going on? What are the issues? What are the concerns? Because I want to make sure that that meeting is productive and that any issues or concerns are going to be addressed. And so, you know, it's important to make sure that you notify in advance, because sometimes it means, because of, you know, schedules, you may need to reschedule the meeting. But the second is, you know, if you have an attorney shows up at the meeting and the district says, well, our attorney's not here, you know, that attorney, once they've said we need our attorney, can't talk to them. So that means the meeting gets canceled anyway, because otherwise you have an ethical conflict, which we don't want to get into. So if you're thinking of bringing counsel to a meeting, to a 504 or a CSE meeting, you should notify the district and provide that contact information so that the district can make their decision. Depending upon where you are in the state, because I will acknowledge New York City has its own little, you know, unique thing, that you may have, the parent has counsel and the district does not have counsel. That really is a different experience. I think for most of the rest of the state, if parent has counsel at the meeting, the district will have counsel too. And it's just basically, you know, not because the councils are running the meeting, but because if there are questions of law or issues that may come up, that's what we're there for, to advise and to, you know, support the understanding of the law as it applies in these circumstances.
I have one. I think I have a good question to end on, because we are approaching that noon mark. This says, with staff shortage, what is the right response to a school not having a special education teacher at all this year?
That's, you know, I think that districts have struggled with this in terms of recruitment. You know, they have, you know, money from some of the ERA and ESSA and all these other funds, but we are competing for the same teachers. And, you know, often one district's loss is another district's gain. We're not getting more people in, we're just shifting people around. You know, the guidance document is very clear that districts are required to have qualified staff. The reality is we can't make people exist if they are not available, but at the end of the day, there may need to be a review of, you know, how the student performed, whether or not they made gains, whether or not they made progress, and to consider whether or not any compensatory or other makeup services or supports may be necessary if and when we do have that. It's not an easy circumstance. The practical reality is districts are making do with everything they can, and they're recruiting round the clock. The, you know, frustration is, you know, no one wants kids to be in a program where they don't have the necessary staff and providers, because it doesn't benefit anyone. Our goal is always to have the qualified staff, but I will tell you, at least in my experience, it is not from lack of searching and pursuit of it. It is just simply, whether or not your rate of pay is as competitive as the next district over, and other bargaining aspects that may be out of the parent's control. But districts have the obligation to have trained staff. They are struggling to find it and to fulfill all those positions, but it doesn't, there's never a pass on the IDEA obligation.